My name is Rich Humpherys. I would like to discuss with you some of the basic aspects of written discoveries, specifically interrogatories and requests for production of documents. Other written discoveries such as subpoena ducis tecum, requests for admissions, depositions based on written interrogatories will have to wait for another time. One of the important things in preparing interrogatories and requests for production of documents is to keep in mind the basic purposes of where we're going in the discovery. And primarily and foremost is to efficiently establish each aspect of your case. And on that point, I would suggest that you consider using the Utah Model Jury Instructions, or Model Utah Jury Instructions, commonly referred to as MUJI. You can look up the cause of action if you're not particularly conversant in the elements and factors of your cause of action. Read what is required in the law for each element of your cause of action, the scope of damages and that type of thing, and it will help you, I think, in crafting the kinds of discovery requests that will assist you in establishing your case. Another purpose of discovery, of course, is to establish, or to discover, I should say, the weaknesses in your case. And finally, to discover the strengths and weaknesses in your opponent's case. All very important parts of the purpose of discovery. Discovery, we should keep in mind as well, is not to harass the opposing attorney, even though he or she may deserve it. It is not to explore pet peeves or to pursue a cause. It is to establish your client's interest in whatever position they are taking. Now, the key is to efficiently use the discovery request. And let's first talk about interrogatories. I find that interrogatories only have limited utility, and there's reasons why. The rules restrict the number of interrogatories to 25, including discrete subparts. Answers to interrogatories are usually written by attorneys. Therefore, you don't get candid responses. You often get objections and qualifications in the answer. Areas of useful information you may seek through interrogatories might be total medical expenses, lost income. It might be things such as names, addresses, and telephone numbers, number of items or identification of items, the kinds of things that you may not be able to ask in a deposition and get a complete response. Bearing in mind that each time you use an interrogatory, you now subtract from the total allotted interrogatories allowed under the rules. So use them wisely. Now, I find in drafting interrogatories that careful consideration of the language will help avoid objections and non-responsive answers. And what I think would be useful here would be to show you some certain kinds of interrogatories that might need some redrafting, yet they are very common, at least in my experience. I've seen them, or similar interrogatories used. Let me have you look at slide 1, which accompanies this presentation. If you look at interrogatory number 1, it reads, state whether you have insurance, and if so, describe the amount of the insurance. Well, I would ask you to view this and the others that we look at with an eye that you're the opposing counsel and you're going to be looking for ways not to disclose information which you may not want to disclose. So you're looking for objections, you're looking for problems with the way the interrogatory is drafted. And so what are the problems with this interrogatory? Well, the first that I see is that it doesn't describe the kind of insurance you're requesting. There are many kinds. There's workman's comp, there's life insurance, there's disability, medical, automobile, homeowners, and a myriad of others. So we need to be specific in that regard. Also, it says whether or not you have insurance, which is a present tense, and whether or not a person has insurance at the present time might be irrelevant. The key time is, of course, during the time in question. Another problem with this interrogatory is the word amount. What does amount mean? Amount, is it quantitative? Is it limits? Is it for a particular kind of coverage? Is it associated with the scope of coverage, and so forth? So there are problems with this interrogatory. What I've done is I've prepared another interrogatory one. If you'll look at slide 2, this is an interrogatory which will hopefully provide some ways that will prevent objections or non-responsive answers. Number 2 reads, describe any medical insurance you or any member of your immediate family had in effect from January 1, 2003 through December 31, 2003. Of course, that would be the applicable time period. Another area which I've seen often with problems is a request that involves legal opinions. An interrogatory such as, what is the basis for your second cause of action? Or what is the basis for your third defense? Well, you'll immediately get an objection that it calls for a legal conclusion or opinion, and therefore we're not going to answer it. It would be an easy fix to simply put, what is the factual basis for your third cause of action, and so forth. And that eliminates that objection. So by thinking ahead and placing yourself in the shoes of your opposing attorney, it's easier to draft the interrogatories in a way that eliminates these problems. Now, the same issues can be examined in requests for production of documents. Now, usually I prefer requests for production of documents over interrogatories because there's no limit on requests for production. The answers you get are not filtered through the attorney's eyes. You get more reliable information, more details, because they're contained in the documents. And finally, by having the opposing side produce the documents, you often get past foundation issues regarding admissible evidence for trial. Now, I've done the same thing, taking some typical requests for production of documents, and I'd like to show how they can be easily remedied when we don't draft them properly. So let me have you look at slide number 1 or number 3, please. It's request number 1. It reads, produce a copy of all investigation reports relating to the accident site. Now again, I ask you to think through that request. What are the problems with this request, and what are the anticipated objections that you'll be getting? Well, first of all, we don't have a time period that it relates to. So, and the accident site, of course, could be any place or any place in time where the accident occurred. So we have to narrow it to a specific time period. We might get an objection for work product, which means that if the attorney has done any investigation at the accident site, that's going to be claimed privilege and won't be produced. The word report is also too limited. Is it anything you want or just reports that you want? If I'm a crafty opposing attorney, I would say, well, I don't have any reports, even though we did an investigation. And that's not what we are trying to obtain here through this request. And also the word site, accident site, is problematic because that just refers to a location. Whereas if we were to use something such as accident scene, now it becomes restricted in time and specifically relating to the accident itself. So I've prepared another request, number 1, which addresses these kinds of problems. If you'll look at slide number 4. I think that we can go through that and you'll be able to see one way to address those problems. Produce a copy of all documents relating to the investigation. Not just investigation reports, but any document relating to the investigation of the accident, which were generated or produced within 30 days from the date of the accident in question. The reason we place that time period is to avoid work product objections, including witness states, photographic records, drawings, logs, notes, reports, and intra-company communications. All of this now is much broader, yet it's narrow to the point where one cannot be non-responsive and must produce these items unless they can come up with some privilege. Let me have you look at request number 2. which is slide number 5. It reads, produce the personnel file of John Doe. Well, what do you see with this request that is problematic? Well, I see first of all that it's overly broad. It requests information which is irrelevant, such as the tax withholdings or the other tax information in one's personnel file. It contains personal information about his family, typically, or could, benefits and other kinds of things that probably is not an issue in the trial. On the other hand, we don't want to be too narrow, so there's a careful line that we have to draw. So I've tried to create a better request, and let me have you look at slide number 6 now. Produce the portions of the personnel file of John Doe that relate in any way to driving under the influence, reckless driving, or non-lawful driving in any way, including any admonitions, warnings, or discipline for such driving. Now we're getting to exactly what the intent is and what we really need to help establish our case. So that's an example of how to correct those kinds of problems which are easily brought into questions when we don't carefully think through them. Let me have you think of another request that I have seen. In fact, I just received this from a very reputable attorney in the last couple of weeks. He asked me to produce and describe all facts and documents that support my case and which do not support my case. Well, in essence, he's asking me for everything in the world, and he's asking me to prove his case. Well, of course, this kind of question is inappropriate because it shifts the burden of proving the opposing attorney's position to me, and that, of course, is highly objectionable. It also asks for everything in the world, which is objectionable because that is not the intent of discovery. Discovery is to ask for specific items and not just to say anything in the world, please give it to me. So that's a good one. I think that is fun to play with, but really has no useful value. Well, I hope some of these things we've talked about are useful to you, and I wish you the best in your practice.